Hi, this is Attorney John Roach. In this video, I want to go over a recent underinsured motorist closing argument using the PowerPoint that I used to secure a victory over the policy limits in this case. One of the themes of this case was that this is a simple case. While the defendant tries to make it complex, it's really a straightforward case of a woman who got struck by a car from behind, struck her head on a headrest, and developed a traumatic brain injury, post-traumatic stress disorder, tinnitus, and dizziness issues. So the simpler the explanation, the better, because the defense explanation of the evidence was very convoluted. They had experts that conflicted with themselves, and it just didn't make any sense. So there were two roads, the claimant's road and the respondent's mode. We call the injured party a claimant in an underinsured motorist case. This case involved expert witnesses, neurologists. The injured party had Mark Desposito, a neurologist and former professor at UC Berkeley, who specializes in the cognitive deficits of people with mild traumatic brain injuries. The defense hired Chitra Venkatasubramanian, also a highly qualified expert in neurology, but in a slightly different field. She dealt with acute stroke victims and acute severe brain injuries and what can be done in the first 24 hours to help them make a decent recovery. The defense neurologist's opinion in this case was that the collision caused a traumatic brain injury, PTSD, and tinnitus. However, at the 12-month mark, my client's symptoms stopped being from the crash and started being from pre-existing anxiety. So that was an opinion that involved a lot of assumptions, and you had to jump through a lot of logical hoops to get there. The defense opinion oversimplified recovery timelines, relied on studies in a one-size-fits-all model that ignored individual variations in injury outcomes, and that also conflated the interaction of PTSD with anxiety. Our version of the events was pretty straightforward. Our expert, neurologist Mark Desposito, testified that my client sustained a concussion, and that involved a diffuse axonal injury, which is where the axons in the brain, which connect the different parts of the brain, is stretched, torn, or compressed, leading to the symptoms that were well documented in my client's medical records and by her treating physicians. Here is a photo of the impact. It was a rear-end collision that was pretty severe, caused a lot of damage to the cars. And it caused my client to strike her head on the headrest. And what happens when someone's in a rear-end collision is their head goes back, and then with the momentum of the car, moves forward. And during that process, the brain moves forward. And the axons inside the brain are stressed. They're stretched, torn, and compressed from that movement. So a normal axon is seen on this image, and that's the connector wire in the brain that connects the different parts of the brain and sends signals. And when those axons are compromised, it can lead to a variety of symptoms. In this case, it was memory problems, emotional problems, and a bunch of cognitive deficits that were identified in neuropsychological testing. Using illustrations, I was able to show what happens to those axons in a traumatic event, because they don't show up on MRIs. This all happens at a microscopic level. And keep in mind there are billions of axons in the brain. So we had to confront the defense arguments head on. One big argument was that an early neurological exam done by her treating neurologist was completely normal. Therefore, she was normal. However, the MMSE, which is a mini mental state examination, is inadequate in detecting the subtle cognitive deficits that we see commonly in diffuse axonal injuries, such as slowed processing speed, executive dysfunction, and mild attention deficits. Fortunately, in this case, both sides had neuropsychological testing, which is well suited to detect these subtle deficiencies following a diffuse axonal injury. Another argument was that my client failed to mitigate her damages by not seeking out and obtaining the therapy that her doctors were recommended. That her doctors had recommended, rather. So we looked at the jury instruction for mitigation of damages, and it requires the trier of fact, in this case an arbitrator, not a jury, to look at the reasonableness of the efforts that the injured person takes in trying to mitigate or lessen their damages in light of the circumstances facing them at the time. We had testimony in this case, and it was important to bring this out, that despite her best efforts, she was unable to find a therapist when her phone calls went unreturned and no one would even see her as a patient. Unfortunately, in the Bay Area, it is hard to find mental health care, especially when you're not paying cash out of pocket. And that's what happened in this case. So a very important jury instruction that we used was substantial factor, which is important in all personal injury cases. And that is the legal test of causation. And it's somewhat misleading. The title substantial implies it has to be maybe the only cause or the primary cause. But the wording of the jury instruction says something quite different. It's a factor that a reasonable person would consider to contribute to the harm, and it doesn't have to be the only cause. It just can't be a remote or trivial factor. Another important jury instruction for our client, who was older, she was 76 at the time of the crash, was unusually susceptible plaintiff. Now, being 76, she had a lot of pre-existing health issues, and that made her more fragile or susceptible to suffering prolonged effects from this concussion. So using the substantial factor jury instruction, the legal test is more likely than not, which is just a slight tipping of the scales that even one feather can tip. So my client sustained a number of symptoms: balance difficulty that led to a fall and a hip fracture, dizziness, sleep problems, fatigue, trouble concentrating, memory loss, headaches, and emotional difficulty with her PTSD. Part of a lawyer's job is to communicate the impact of the accident on someone's quality of life. How bad is the harm? How long does it last? And how interfering is it with someone's day-to-day activities? So how long does the harm last? I was able to use the defendant's own neuropsychologist, who testified that given the chronicity of her complaints and how long it's lasted and her age, he didn't see her condition as improving, meaning it would last for the rest of her life. Similarly, the claimant's neurologist, Dr. Desposito, said that this was more likely than not a lifetime problem. So life expectancy is determined in personal injury cases according to a jury instruction that has tables showing how long someone's expected to live. and a 78-year-old woman is expected to live 9.1 years. Translated into days, that's 3,321 days. And it had been 750 days from the time of the crash to the time we were able to get in front of an arbitrator. This is a case that only involved non-economic damages. One of the items of non-economic damages, colloquially known as pain and suffering, is physical pain. So we had a lot of physical pain in this case when my client fell and broke her hip due to the dizziness. She also had physical pain from the headaches and from the tinnitus. Mental suffering was a big item of damages in this case. My client was diagnosed with PTSD. Her primary care physician testified she had depression, anxiety, and she was frustrated with her lack of getting better. She was ultimately diagnosed with PTSD. She was physically impaired with constant ringing in the ears. Even the defendant neurologist conceded that the crash was the cause of the ongoing tinnitus. That's not something that she could say was caused by anxiety. And we were able to prove that the anxiety was a result of the crash and not a cause of her ongoing symptoms. She had an incredibly sad loss of enjoyment of life. And she was inconvenienced by no longer being able to drive as a result of her symptoms. She would get lost and she would drive erratically, suddenly slowing down to a halt on the freeway, causing her family members to tell her, it's time to stop driving. This really limited her social interactions with her children in the Bay Area and her best friends. She missed out on a key event in her life, which is every year she would have a reunion with her siblings in Australia. She was the oldest of 11 siblings, and she helped raise her younger siblings. And she took immense pride in seeing what wonderful lives they had developed. Unfortunately, she missed out on the reunions after this crash. Instead, she was living with daily physical impairments from the dizziness, the ringing in the ears, daily cognitive deficits, making it difficult for her to enjoy reading. And the impact that this had on her daily life was to take away her independence, diminish her enjoyment in family and community, making her feel useless and depressed. The loss of driving led to isolation and emotional suffering. Every day she was living with constant ringing in the ears that made it difficult for her to enjoy simple activities such as watching television or to get a good night's rest. So when it came time to quantify the damages, we used a per diem approach, where we took the different items of non-economic damages in the jury instruction and put them in categories of physical pain, mental and emotional suffering, loss of enjoyment of life, inconvenience, and anxiety. And we put a dollar amount for the past and future period for each one of those items of loss. Multiplying all those categories together, I believe that the law and evidence justified an award of $3 million. And that's what I told the arbitrator this case is worth. The defense said it was worth a mere $75,000. And when I concluded my presentation, I challenged the defense to answer 3 questions. Number 1, how could the defense neurologist determine that the PTSD had resolved if she had never even met and evaluated my client? Number 2, why would the anxiety and depression suddenly become severely disabling and be the cause of all her other symptoms if the accident didn't significantly contribute and make those symptoms worse. And third, I challenge the defense to tell the arbitrator what was wrong with how we were evaluating the case. As in many personal injury cases and trials, the defense completely ignored these questions. Ultimately, we won the case, and the arbitrator awarded $250,000 over the policy limits for a total award of $750,000. Thank you for listening, and if anyone has any questions or would like a copy of my PowerPoint presentation, please reach out to me. My number is 415-851-4557, or send me a message through my website, www.representmyinjury.com.